You want it? We have it. The hottest mortgage and real estate strategy broadcast in the nation. A Smarter Way Home with your host, Danielle Boote and Victor Bals. 50 years combined experience, ranked in the top 1% in the nation for home loan originations 2020. Promise to expand your knowledge, utilizing creative mortgage financing and home buying strategies. Build a bridge for a better quality of life. Get your brain cells firing for a smarter way home. And welcome to another episode of A Smarter Way Home. Modern mortgage solutions and home buying solutions for real estate professionals and consumers alike. My name is Victor Bals, loan originator for a long time. I think it's about 22 years right now. And I would like to introduce my co-host. My co-hostess with the mostest, the loan officer extraordinaire, Mrs. Danielle Boote. How are we this morning?
I'm fabulous this morning, Victor. How are you?
All right. Our intro, I kind of got that down.
You do. It's like
the
just
same.
Rolls off the tongue.
Every time. Well, it's a wonderful day here in the old Detroit area. It's kind of a little bit rainy here. But we got a special show today about real estate law. Very important in today's marketplace. So, Danielle, why don't you give us a little intro on our guests?
Absolutely. It is my pleasure to introduce Abby Cooper. She is an attorney with Cooper and Riesterer Law Firm in Brighton and has been a practicing attorney for 19 years and I believe is also a Brighton native. So she'll tell us more about herself, but her law firm is, I believe, the prominent law firm in Livingston County for all things real estate. They specialize in several different areas. She can tell us more about that, but Abby is very involved in the Livingston County Association of Realtors, has been for many, many years, and has been kind of our go-to in the real estate community. She is, the first one we refer to when we have clients that have questions, problems, concerns about real estate, particularly, which is specialized. Over the years, I remember being very young in the mortgage business. I was maybe 20, 21 years old. I'd been in the business less than 2 years. And back then, I had a client who hired an attorney to review their closing docs, which recommended practice, for borrowers. And the attorney called me because he was not a real estate attorney, didn't understand any of the mortgage papers, and was asking me questions. And at that point, I was going to college part-time, working in the mortgage business full-time, and I went, dude, why are you asking me? You should know this stuff. So I think it's extremely important for people to understand that attorneys specialize in things, and real estate, whether it's commercial real estate, residential real estate, it's a huge specialty, and not everybody is qualified for that. So, hiring your estate planning attorney to review mortgage docs or closing docs or a purchase agreement is probably not in your best interest.
No, it is not.
Welcome aboard, Abby.
Thank you.
Yeah. So, tell our guest a little bit about yourself. What brought you into being an attorney, one, and two, a real estate attorney, and tell us a little bit about your journey and how you got to where you're at today.
Well, I am a Brighton native. I grew up in Brighton. My family owned a nursery and garden center in Brighton, and my parents were teachers, and I just really wasn't that interested in going into the family business for trees and gardens, and I just really did not know what I was doing there. So I developed a love of the legal system, and I liked following rules. I liked advocating. I liked giving speeches, and I went to Michigan State for undergrad, and I loved my liberal arts degree, and went on to Wayne State Law School. It took a couple years off, and I just sort of always knew I wanted to be an attorney. Beginning, I think in high school, I graduated from Heartland High School, and just kept following that path until I got here.
Did you start in real estate law, or how do you become? I want to be a real estate attorney.
So I didn't. I feel like I'm very much where I need to be and was meant to be. But yeah, when you start out in law school, you sort of know the general practice of criminal law, or personal injury. Those attorneys you see on TV. But I really didn't know much about real estate law, but it's sort of a natural fit. My father-in-law, Dale Cooper, was a real estate attorney and business attorney in Brighton. And my path sort of brought me here. But after going to law school, I worked at the Court of Appeals for a year, and I got to help judges write opinions on all different types of cases. And I really gravitated towards the real estate ones, and I asked for those special assignments on all the real estate cases. And after being there a year, Dale and Kathy Riesterer invited me to join their practice in Brighton beginning in 2005, and then they just really taught me the ropes. So my law firm began in 2000. Dale and Kathy merged, came together and created the firm. And Dale had been specializing already in real estate in the county for several decades. So when I joined, I was the third attorney, and they both really just taught me what I needed to know, and introduced me around to the county, and joined the Livingston County Association of Realtors, and they really got me in a great spot.
Okay, so that's your work life. What about your personal life? Married, kids? What's your hobbies? What do you do?
I'm married. I have two sons. One, my youngest son turns 15 today, so
That's cool.
happy birthday, Finn. And my other son is 16. They're freshmen and sophomores at Brighton High School. My husband is Bradley, so that's I joined a practice with Dale. Dale's his father. And we live in downtown Brighton. We live next door to my husband's sister, and his parents used to live next door to us as well.
Oh, how cool!
But his dad and my stepmother passed away, his stepmother passed away last year.
Aww.
So we recently sold that house to a fun old neighbor of mine. People in Livingston County sort of stay here, and it's still a really nice little corner of Brighton Lake Road that we have there. So we love to look out at our lake. We live on the creek. I love to run. I'm signed up for a half marathon coming up here in a couple weeks. So in my spare time, I did the I'm going to do the Dexter to Ann Arbor run.
Oh, I did that last year. Oh. Yeah. Well, I walked it though. I'm an old guy. Old guys walk. Really old guys. Well, very interesting. So, God, there's so many facets here, and we could go all over. So, you work a lot with realtors. What is a typical question or a case that you would get from a realtor and or a consumer? What generally starts off a relationship with a consumer or a realtor for real estate advice?
I get a number of different questions. There's a lot of questions from buyers post-closing if they've got an issue with the house. What kind of liability does the seller have for disclosing or not disclosing items to me? Pre-closing, especially lately, I've gotten a number of questions on, well, someone wants to back out, a buyer wants to back out, seller, what can I do? Can I force the sale? Or a seller wants to back out, buyer says, what can I do? Can I force the sale? That's the predominant question right now is folks trying to, I think, get out of transactions, or there's a dispute over the earnest money deposit. I'd say those are the top three.
Well, I just had a situation on a very large transaction where we've had the appraisal, the inspection passed, and the buyer got cold feet, says, I want out.
Yep.
So they're going to forfeit their earnest money deposit. Is that a typical situation?
Yes.
That you will see? And what rights would a buyer or a seller have, or is it just, it's contractual? Look, you backed out. How does that work?
So you're exactly right. The first thing I say is, well, what does the contract say? Send me the purchase agreement. Let me look at the purchase agreement. I mean, we have the Livingston County Association of Realtor base form, which most folks use around here, but not always. And so we got to see what the contract says. What does the default clause say? And if there is a default, what are your remedies? Is it limited to just, if it's a buyer backing out, then of course we're looking at what are seller's remedies. Often the default clause would say if buyer defaults, seller gets to keep the earnest money deposit as liquidated damages. And if so, then that's the only, that might be the only remedy available. It might say any and all remedies available. So you could, try to get buyer's forfeited deposit. You could sue the buyer for specific performance. You could sue the buyer for damages if you end up selling it for less. But even before we get to the default clause, I'll look at the rest of the purchase agreement to make sure there is a default. If buyers getting cold feet, are we beyond our due diligence period? Is it beyond the financing period? Is there some other way buyer could, posture buyer's, decision not to buy?
Go ahead.
Well, one difficult thing for lenders when it comes to a buyer with cold feet is many times they will call us and say, can you reject my mortgage? Can you deny my loan? We have also had occasional clients that will withhold documentation and say, well, we didn't give you a bank statement, so you can't approve the loan. It's a very tangled situation for buyer, seller, lenders, realtors when somebody wants to back out of a transaction, because a lot of times people don't realize, no, this is a legal binding agreement that you are signing when you write the offer on the home. And I have told people many times, no, I cannot reject your mortgage. Based on the fact that you didn't give me your asset statements, because we had enough information to approve the loan. You have to go in a different direction. I mean, as lenders, we have federal regulations we have to follow. When we can deny a loan, how we deny a loan, and for what reason.
Yeah, and in any contract, there is a duty of proceeding in good faith, and so to do something like that with the intent of creating a default situation, that in and of itself is not, it would be actionable.
Well, let me ask you a question. What about a situation where husband and wife are going to buy the house together and they're past the diligence phase, everything is good, their loan is approved, and now they talk about, we want to get a divorce, we want to get out of the transaction. Is it still contractual? In a sense, where the seller could hold them to it and say, we don't care. You agreed to buy the house whether you're getting divorced or not.
Yes, unless there's some sort of provision in the contract that, they could hold on to that would allow them to get out. The fact that they're no longer married, that's between the two of them.
Okay. And if there was a car accident or something like that happened, it still boils down to the contract. And the only way we could deny them if that particular person in the car accident was able to not make income, and we had to utilize that income to qualify them for.
Yes, I think that you've hit it, square on. That if something in life changes, that would impact their ability to get financing, and financing is a contingency of their requirement to purchase. Then yes, at that point in time.
I mean, if someone loses their job, then we have the ability to deny the loan.
Right. Well, here's another. I just got all these ideas coming in my head, but here's another typical situation. Our buyers will go in to look at a particular home. They get through the inspection and find out there's mold or something like that, or there's something wrong with the home, and they back out. They go ahead and relist the property. Is that seller now obligated? Well, ethically, they are obligated to disclose that to the new buyer. But I see where sometimes they don't disclose that. Yeah. How does that roll?
So they would be, the only disclosure requirements on a seller is what's under the Seller's Disclosure Act. And that is supposed to be, what seller understands in good faith is in seller's head at the time that they engage with a buyer. So if they're on buyer number 2 and buyer number 1 has made them aware of a condition, then they should amend the seller's disclosure statement so that buyer number 2 has the accurate information, what seller knows at the time buyer 2 comes to the table.
Okay. Well, I've had another similar situation, and I hate to get a little darker here, but where the clients were buying a home because the seller, the home, someone was killed in the home. Is in the estate, I guess the trustee who's handling the estate, are they obligated to disclose that there was a bad thing that happened in that home?
So I'm very glad you brought this up. I know a number of folks have heard me give this statement a number of times. So first, in Michigan, a trustee is a fiduciary of a trust. The trust is the owner of the home in your situation. The trustee should not fill out any seller's disclosure statement unless the trustee was an occupant of the home. The thought being is the seller is supposed to communicate to the buyer what seller knows. If the trustee has never lived in the home, trustee doesn't know enough to be able to accurately disclose to a buyer what's going on with the home. So there's an exemption in Seller's Disclosure Act that says that trustee does not have to fill out a seller's disclosure statement. And I would recommend this trustee not do that, because if you voluntarily fill out the seller's disclosure statement, then that could create an actionable situation for you. So that's number one. Number two, in your scenario, if the trustee were in a position where they had to fill out that seller's disclosure, there's of course, no question about that on the disclosure. And so they do not have to tell the buyer about that situation unless the buyer asks.
Okay, well, what if the trustee was the brother of the deceased? Obviously, the trustee would know something of what happened?
It goes back to say the trustee doesn't need to fill out the form because they didn't live there. They can't answer any questions that they don't truly know the answer to. Does the furnace work? Does the garbage disposal work? You know, things of that nature. And again, she said there's no question that said, did anybody ever violently get killed in the house or does anybody die here? You know.
So seller's obligation, so if you flip it to even, anyone, someone might, if they have to fill out this disclosure, their obligation as the seller is to fill out what the disclosure says, and again, to answer any question that the buyer asks honestly and truthfully. So, in certain purchase agreements, if there's something that a buyer really wants to know, have a representations and warranties of seller and ask seller a bunch of stuff. Then seller needs to, answer those questions truthfully.
Well, I personally got whacked on seller disclosures. I had sold a home and I filled out, first of all, I tried it for sale by owner. We'll talk about that in a little bit. I did not seek any attorney advice. I ended up selling it with a real estate agent, but on the seller disclosures, I'd filled out, had the basement ever leaked? And I'd put no. But when I'd first moved in, there was a small leak down there, and I remember patching it up, and then I painted the basement, and I really kind of forgot about it. So 6 months after I sold the home, the seller comes and says, hey, look, here's a bill. On the seller disclosures, you said there was no leak, but it's obvious you tried to do a repair and cover it up. Here's the bill. So instead of doing it illegal, I thought, yeah. So I paid. I would assume he was correct on that. I would have been better to say, yeah, it did leak and I patched it.
Correct. That's exactly what you should have said.
Okay. Yeah. So I had to pay on that one. And as we talk about for sale by owners, I get so many of these. I'm going to sell it by owner because I'm not paying commissions. I'm going to do it myself because I've owned a home before. And we see a lot of problems with one. There's a lot more paperwork. People really don't understand. Do you see that with for sale by owners? Is that a part of your business? Do you have a lot of for sale by owners? And do you recommend anybody trying to sell their home by themselves to seek legal advice from a real estate attorney?
Yes, we do represent a number of for sale by owner folks. We will help them with their purchase agreement and help them get to a title company. Usually the buyer, goes to the mortgage folks on their own, but typically if we're on the seller side, we can draft that purchase agreement for them and advise them regarding their disclosure requirements, including the seller's disclosure statement and the lead-based paint statement. So yes, if a seller is going to elect not to use the services of a realtor, then at the very least, I would recommend they consult an attorney.
Yeah. Do you see problems with that at all? Do you ever see people coming after the fact? I did it for sale by owner and now it's a mess. The stuff turns up.
I haven't seen. I can't say that there's been a difference post-closing in issues coming up after the sale, and it might just be the volume of that realtors handle. They handle a lot more transactions through their services than I do for sale by owners.
What I see here is, okay, we can get started for sale by owner, but when the transaction becomes a little bit more difficult and now there's price changes, there's stuff here, there's repairs, all the addendums, these for sale by owner people, buyers and sellers don't know how to write these up correctly and all that stuff.
Correct. And I'll qualify this. A lot of the for sale by owner we do is, I would say, more familial transactions.
Yes.
It's a lot of, father selling to the son, or grandma selling to, a grandkid or aunt and uncle, or their neighbors. We live in the lake community, and a lot of these lake neighborhoods, they sell to, someone down the road, someone they've known for 30 years. So there tends to not be a lot of complication in those. But certainly I think in the third party transactions, the arm's length transactions, that all of those contingencies that you're talking about, all those situations, those folks are not equipped to handle that.
No, you could have decades of war stories. So I saw a transaction probably about 10 or 15 years ago, and it was local, where I had a buyer enter into a contract with a seller to buy his house, and it was a higher priced home. And there were friction between the buyer and seller. We had the mortgage in process. I believe the appraisal was done. We're moving forward. And the seller decided to sell the house to somebody else for cash. Literally sold it right out from under the original buyer, who was in a legal contract. And at that point, what is the first buyer going to do? You're going to sue this guy? Because, there was definitely just cause there, but this buyer was out of home, needed to go find another one, and would have had to incur a lot of legal fees in order to go after the seller, and the house was already legally sold. And people don't realize that, my goodness, real estate can be intricate. Not everybody is honest, upfront, and ethical, and there's a lot to it. Yeah. There's a lot to it. And they come to us as lenders, go, well, can you help me with this? No, we don't write purchase agreements, and we can't, you don't even know, if you can't have the conversation of how to structure an offer, how your financing comes in, you probably shouldn't be doing this on your own, and absolutely do need legal counsel.
Yeah. In those transactions where they don't, the buyer and or the seller, they don't have an agent, it brings a heavy burden on everyone else that's in the transaction.
Oh, yeah.
And puts other folks in positions that it's not within their wheelhouse to handle. The realtor and the agent's there for a reason, to give that professional advice.
Absolutely. In this current market, we're seeing so many people pay cash for properties too. Parents coming in and paying cash because they're trying to help out the kid, or whatever it takes to get an accepted offer. Excuse me. But I had a situation where a gentleman paid cash for the property and decided, I'm going to save money, not get an owner's title policy. Come to find out, he come to do a cash out refinance to pull someone in. Cash out, they found a $200,000 lien on that property. Do you come across that type of stuff too, where there's liens on titles? Does that suck you into getting involved with these real estate transactions?
Yes, I would say you asked me that question earlier, what kind of typical issues might bring me into a buy-sell situation, and title issues is a big one.
Give us an example. What would be some title issues that would affect a buyer? Me, the buyer, I want to buy a home, and now the title work, and now there's problems with the title. Give me some examples.
So are we looking at a buyer after a closing, or a buyer
during a transaction?
So yes, so during the transaction, those are going to be seller issues that come up on title that sellers got to deal with. So some of the things that I might need to get involved in is if you've got an old attorney lien from a divorce, if you've got a IRS tax lien of some variety, those can take some time to get paid off. Or if you've got, if you a lot of times land contracts, during the 80s, the 70s, 80s, there was a lot of land contracts in this area and throughout Michigan, basically because of interest rates and some other reasons. When folks did land contract transactions, a lot of times they would never get a deed. So there's a missing deed in the chain of title, and we've got to go fix that, either go to the seller, who may be deceased, and try to get a deed, or we'd have to file a quiet title action in the circuit court to get that issue resolved. Another situation is if there was ever if the property was ever purchased on tax sale, foreclosure sale from the county, Most of those titles aren't insurable. And so we've got to look to see what the notice provisions were for this foreclosure action done by the county. And then we either approach those folks who are still on title, or we go and file a Supreme Court action.
Well, back up a second. So if I go down to the courthouse and I buy a foreclosure thinking, oh, good, I just bought a foreclosure, it's clean as a whistle. Not so true. There could be, what do you mean? No one will insure. I can't get owner's title policy on that?
You will likely have problems, very, very likely. So we tell all of our clients, if you have a foreclosed property and you want to sell it, let's get our title in order first before you put it on the market. So you're not.
Is this before I buy the property, or the old adage, buyer beware?
Yeah.
Do I have to be careful buying that foreclosure property, and do I have time to even do diligence with a real estate attorney to make sure I'm buying a clean property?
So it just depends, because a lot of times, sometimes you don't know what's going up on the auction block until it's there. But yes, any good savvy investor should look at the title before they buy, to make sure, first of all, you're buying a first lien. I've had a client who, the one time he didn't pull title, he bought a second mortgage, thinking it was the first. So he paid way over value for it, thinking other bids would be coming in, and not overvalued for the property. It was undervalued for the property, but over the amount of the mortgage. So the second mortgage. The second mortgage. So the second mortgage was about, I think, 60, and the first was 120. The property was it was in a pretty bad shape, but the property before improvement was probably worth 2-ish. And so my client bought the second, thinking it was the first, bid over $100,000 for it.
So now he owes $240,000 on a house that's only worth $220,000.
Correct.
Wow.
So we're just trying to stop the bleeding. And he's done this a number of times. He knows what he's supposed to do, but that one time he didn't do it.
Yeah.
So why did he fail to do what he's supposed to do, get the title? Was he trying to save money?
I tell you what, he did it himself.
Oh.
He did it wrong. So,
well, now he's got a college education paid for.
So he apologized to his title folks and said, the one time I do it without you.
Yeah.
So before you purchase a foreclosure property, you should absolutely pull that title work to make sure you know what you're getting, and that you're bidding on the first and not the second, or you bid on the second knowingly.
Right.
The other question you asked is, okay, so once you do buy a foreclosed property, then if you're flipping it or you're living it or whatever you're doing with it, and then you want to go sell it at any point in the future, most title companies, most title insurers won't insure that title to your the end buyer if it's been on foreclosure, because they don't know whether the notice process was appropriate for the underlying foreclosure. So I have to explain to people all the time. So it's really not an ownership issue. You own the property. If you bought it from the county and you got a tax deed, you're the owner. But what it is the title insurance companies have taken a position, well, I know you're the owner now, but what I can't say is that the county did the foreclosure process appropriately. So they'll accept from title that the person who got foreclosed upon, they'll show that interest on the policy or on the commitment as an exception. And so if that happens, what I recommend doing is we go and we try to find those folks. Where are they? Are they around? Or we get the notice documents from the state of Michigan, and if we can prove to the title company that person received notice of the foreclosure proceedings by certified mail, then they typically will insure it.
Wow.
And if all that fails, if we can't find the folks, we can't prove they received notice, then we go and we file a quiet title action with the circuit court, and we can get you the relief one way or another.
Timing. How long does that take in a typical situation? I mean, is this days or is this a weeks, months process? Months.
Yes.
Better extend that rate lock.
Well, that's an interesting topic, because I actually have a file that got held up for just that reason. The seller purchased it from the county or state in the tax foreclosure, fixed up the house, flipped it to sell it. We had, of course, 2 different real estate agents, and they were trying to do 2 different title companies. And we've been literally, this file's been ready for weeks. We're beyond the rate lock. I've already extended it. And the buyer's title company couldn't get kept saying, we can't get this documentation. They needed something from, it must have been the city or the county, saying that this was done this way. And luckily, my assistant called the listing side title company and said, what is going on here, folks? We've got problems. The buyer's ready. Seller's not performing, and we have rate lock issues. And the first title company said, oh, we've got all the documentation we need, but we won't share it with the second title company. They either have to do the work themselves. So I just made the executive decision to say, guess what? We're closing with one title company. We're not splitting title. Call the buyer's agent, let him know. And the buyer's agent was not experienced and had no clue what was going on. But, this is still a situation. It doesn't matter how long ago the house was foreclosed upon or whatever the situation was. We run into odd title situations that will hang up a buyer. And the buyers were super grateful. Like, they're closing this week. They're super excited because they thought they'd be moved in by now, and you just don't know what you're going to run into with seller.
Oh, and that takes me down another rabbit hole here.
Oh, no.
So I go buy a house at tax foreclosure at the county. I sell it to my kid on a land contract because she doesn't have credit or something like that. And she pays me off in 5 years, and she has the deed. Now, she goes to sell the home. How would that affect it? Because there was never no title work done.
So then...
Would she be in the situation where it's going to be uninsurable?
Yes.
Wow.
So if she gets a deed from you, she gets a warranty deed from you, you are warranting good title, but as a practical matter, she inherits whatever came before you. So she could go to you theoretically and say, hey, Dad, fix this for me.
Could she sue me?
She could. She could. Hopefully.
Yeah. Get in line.
Well, Victor, do not get into buying and selling real estate at that level. You are not a realtor.
Well, I'm just, this is stuff. And now this just brings up another thing. Ladybird deeds.
Yes.
Were you thinking of the same thing?
Yes. Yep. That was my next question too. So one of the things, and let's talk a little bit about common real estate, let's call them mistakes or practices when homeowners think they know what to do to estate plan for their house. So a couple of issues that we see frequently is that people will add family members to the deed after closing for various reasons. Sometimes it's a situation where you put a spouse on title afterwards, fiance. I've seen people put boyfriends, girlfriends on. That can be very problematic. But Ladybird deeds have all of the sudden, in the last, I would say, 2 years, have become very, very popular.
And explain what a Ladybird deed is, Danielle, for our listeners.
Well, do we let Abby explain
Oh,
that?
yeah.
Let's let Abby explain that because she will probably do it way better than I can.
So a Ladybird deed is where you, upon happening of an event, and in a Ladybird deed situation is upon the death of the owner or the grantor. Upon the death of the grantor, the property automatically goes into someone else's hands. So in a Ladybird deed situation, typically people will have it such that upon the happening of the death of the owner, the property automatically goes into that owner's trust. It could go to someone else. It doesn't have to go into a trust, but a Ladybird deed is where that person maintains all control and authority over the property. They can buy, sell, mortgage, do whatever they want to do, as long as they're alive. And if upon their death they still own the property, then the property automatically goes into someone else's hands.
So here's the problem that we have with the Ladybird deed. Fannie Mae, which gives us our conventional mortgage guidelines, does not acknowledge the Ladybird deed. So if we have a client in a Ladybird situation, okay, and the grantee of that deed is not, for instance, a spouse, which usually it's not. I've seen it be, it's usually children, okay? Fannie Mae requires that we take it out of the Ladybird deed to close the mortgage, and then we have to refer them back to the attorney because the title companies won't touch the Ladybird deed. They're not going to put somebody back into a Ladybird deed situation. And what I don't understand, because I remember Ladybird deeds 30 years ago. They were a thing in the 80s, in the early 90s, as I recall. We just didn't see them anymore. Now, all of a sudden, they're coming back. And I guess my question is, I personally have a trust, and all my properties in my trust. I look at that as a better planning tool and don't know why somebody would do the Ladybird deed versus the trust. And then people don't understand, from the lender's standpoint, what Fannie Mae is looking at is that you could give the interest to this property to someone else upon your death that has no obligation to pay that mortgage. There's no responsibility there. Now, obviously, even in a Ladybird situation, if, let's say, the owner passes away, the house goes to their children, and there's an underlying mortgage. If the children want to keep that house, they need to pay the mortgage.
Correct.
Right? If they don't pay the mortgage, the house will be foreclosed upon, regardless of who's entitled.
And that will show up on their history as a foreclosure in their name.
Correct.
Which creates another can of worms in the mortgage business.
Right. So, that you look at that and go, well, that could be dangerous, because what if your children are not in a position to maintain the property or deal with the property? You just don't know, where the state of that family member is necessarily going to be at the time of somebody's deceased.
Yeah. And, the reason in that situation they might choose to do a Ladybird deed would be so that those children don't have to go to probate that parent's estate. So it saves on the cost of and the time of that. So,
but the trust would do that as well.
Yes. So a trust absolutely avoids probate. That's the whole point behind a trust one of the points behind a trust is to avoid the cost and expense and time of going to court and appointing a personal representative and having the court oversee the process of probating that person's estate. A trust, as long as the trust owns that person's assets, can do all of that without ever going to court and paying for those fees. And the trust can appoint certain people outside to have all of the authority to do everything on behalf of that person.
Well, one of the problems with putting anybody on a deed to a property, first of all, inheriting a property, even if it's free and clear, there are expenses, okay? There's property taxes, homeowners insurance, utilities. Inheriting a property, as great as that seems, is not always a good thing, okay? Because what if the person inheriting it can't afford that at that stage of life? The other thing that we've seen, and I've seen this multiple ways, multiple times. So I had a client whose parents put him on the deed to their house. They were elderly. Both mom and dad passed away within a relatively short window of time. They both had significant health issues, and they didn't keep up the property in great condition because of their health concerns. So they pass away, they have a mortgage on the home, and they happened to put their son on the deed. Well, the son, and he called me when he was going through this. He didn't know who to turn to. So he called me and said, hey, Danielle, I don't know what to do here. I can't afford mom and dad's mortgage payment. The house is in poor condition. Based on what they owed and at the market at that time, there was not really a lot of equity in the home. So he just let it go back to the bank because he didn't want to deal with trying to sell it or anything of that nature. Well, the next time I did a mortgage for him, all mortgage companies do a public record data search. And now we have a foreclosure coming up. It's not on his credit, right? Can't see it on the credit report.
Because he didn't owe the debt. He didn't owe the underlying debt.
But the mortgage the foreclosure came up on his history because his parents quit claim him on that property.
Because he owned property that was subject to a foreclosure.
Correct.
Now,
so
could he refuse to say, I don't want nothing Ladybirded to me? Or
well, this wasn't a Ladybird.
Okay, this is just deeded on.
They just deeded him on.
But does he have to sign to acknowledge the fact that he's on there?
No.
So I could deed you onto my property, Danielle, and let it go to foreclosure, and you're on the hook.
Correct. The only people that will sign the deed, for instance, you deed me or anybody else onto your property, would be the people that currently are owners. So if you and Maya own a property and you add your kids on it, they don't have to acknowledge it. So for my client, what I had to do is I had to dig and prove that he never had any mortgage on the property and to show that his parents had only put him on. I've also seen similar situations that people just don't know. Their mom and dad put them on the property, or people lose. Like I've seen first-time homebuyers that wanted to take advantage of a special first-time homebuyer program. And again, you look at their credit, they appear to be first-time homebuyers and nothing's out there. But then you do the public record data search and guess what? Somebody put them on a property up north or who knows where. And guess what? We don't count. They're on a deed. You are on a deed to a property. You are no longer a first-time home buyer.
So you can't qualify for rural development or you can't own any other real estate with a lot of these programs.
Correct.
So just for your future information and use, so the way the law works is the buyer has to accept delivery of the deed for it to become effective. So you can't. So Vic can't put you on his property unless you accept that.
So
conveyance.
what's the legal process for that? Because I've never seen that happen.
Because you don't. I mean, I'm telling you, that's what the law is for a delivery of a deed. But I think your defense would be, I had no idea. I never accepted delivery of the deed. I believe there might be a presumption once that deed is recorded with the Register of Deeds. It's possible the law also builds into it a presumption of delivery. Okay. But you're right, there's vulnerability there because the deeds don't require a signature from the grantee. Right. So but that legally that's your defense to those kind of situations. Is I never knew, I never accepted delivery, and so that deed could be probably potentially.
But I think in most cases somebody knows that they're being put on the deed and they don't think about it. Somebody told me a story recently of a property up north. It was a family compound. It was like 40 or 50 acres. And the father had bought this property decades ago, built the family compound. And as the decades went on and his children became adults, he built multiple homes on the property so that like each child in their family had a place to stay at mom and dad's compound. Well, the parents ended up passing away. And now you have a very probably expensive tax bill. I don't know if there was an underlying mortgage, but now, the father wanted this property to stay in the family. But now you have a huge parcel of land that has maintenance, bills, multiple properties to upkeep. And what had happened was that it was a large family, multiple children. Nobody could afford that, except for one son who had a good career and decided that he ended up buying his siblings out of the estate and he decided to keep it. But even at the time, the story that I had heard was, guess what? The properties needed roofs. They needed maintenance. Again, it was an elderly parent situation who, probably put all of that on the back burner as they aged. And you go, well, this unless a family member for something like that, like let's say you got this special family property up north, the parent willing this to their children needs to create an asset base to maintain it. I look at that. I own real estate. I have children. And when I look at that, I go, okay, what am I going to do with this, with my kids in the future? Because it is a liability. It's not just an asset. There's always a liability with real estate, and willing it to your children as this gift when it's a flipping liability. And guess what? If 4 out of your 5 children cannot afford that at the time of your passing, and you want, you're making everybody swear on your deathbed that they're going to keep it in the family for 1,000 years. You just go, this doesn't make sense. Dad should have stuck some money, put it in a trust, and created a fund for the family to be able to maintain the property. And you go, it wasn't good forethought there. And I also think, unfortunately, sometimes as people age, they don't think about what it's going to look like in 5 or 10 years. And, luckily, again, the one brother bought his siblings out, he could afford to keep the property. He upgraded everything, and then he allows his siblings to come and enjoy it in grandma and grandpa's honor. But you go, my Lord, that you can't assume that everybody's going to be able to do that.
Yeah, and that's where the good sound planning comes into play. And you can do an estate plan, you can do a trust, you can do all kinds of different things if you sit down and think about it ahead of time. We also, especially for elderly folks, when they're looking at property, passing it on in whatever way might suit them best, it also is good to think about Medicaid qualification.
Yes.
So our firm we recently acquired the Milwaukee Law Center for Elder Law. So we purchased that firm last year in 2021. And so we've added an entire elder care law planning department to our firm, and I'm not a part of that. And you talk about specialty; that's not my specialty area. But as a real estate attorney, I know enough to say, okay, we need to get you to these folks. Here. And you don't want to, elderly folks, they might want to give property or plan for that conveyance to their heirs, but we have to do it in a smart way so you don't disqualify yourself from future benefits that you might be able to get.
Well, you as a professional real estate attorney, you're obviously seeing that when someone comes in, there's a lot of sandboxes. You can handle the real estate, but in many cases that they need the elder law for estate planning, and you need to discuss it with there's certain your CPAs and the financial planners. All you guys got to talk on the same page, and you all have to work together. Do you have a network of those individuals so our consumer can come to a one-stop shop, and Abby is the traffic cop, I guess, to direct to where everybody goes?
Yeah, absolutely. That's a really good point. Is much like your residential real estate transactions where you've got all your professionals doing their role, any kind of asset acquisition or asset sale, a commercial lease, a commercial purchase, any of that stuff, you need all of your professionals at play. When you need your tax professionals, you need your insurers, you need your CPAs, you need all of those folks to come together. So that's one of the things that, yes, I would do with any client is if I'm reviewing something, I'll say, okay, have you consulted your CPA? What do they think about this? I've drafted it this way, give it over to them, get their input, or I'll get a commercial lease provision in my inbox, and it's got an insurance provision in there. And I say, okay, let's get it over to your insurer. Is this adequate coverage? Is that's not in my wheelhouse. I know enough to say, let's consult the folks who do know.
Mm-hmm. So let's talk about waterfront properties in Livingston County. There's a few. We have a lot of lakes. We have chain of lakes. A lot of residents flock to the county for the ability to own property on waterfront, but that brings some challenges legally sometimes with ownership, riparian rights, and actually how the properties were deeded or developed originally. And many of these properties were, developed about 100 years ago. Mm-hmm. And our rights and property usage was very different back then. So let's dig into some of the challenges that you have seen locally in regards to those things.
So I guess there's a couple major things I'm seeing right now. One is these older plats, these lakefront properties were developed as platted subdivisions, and 70, 80, 90, 100 years ago. You're absolutely right. And the lake levels might have been in a different spot back then than it is today. And those subdivision lots were platted with definitive boundaries. And now the lake might be 50 feet away from where those lakefront lots were platted. And so what's come up for a number of different reasons in the buy-sell context or in the context of a homeowner wanting a zoning approval from the municipality, it's popped up that while that person maintains a yard all the way to the lake and appears riparian and uses riparian rights, in all actuality, because the platted sub is 100 years old, there's 50 feet between the lot that person owns and the waterfront. And so in that context, it comes up if that person might be wanting to put on a deck or tear down an old cottage and put up a bigger house. Then they go to the township and they need to have certain minimum lot coverage. They need certain setbacks. And in order to qualify for what they want to do, they need to count all of the property they occupy. But they don't own all of it. They only own part of it.
According to the maps, we're building in the water.
Correct.
Yeah.
So, that is a big issue. And so some of the plats, if you read the plat from 100 years ago, some of the plats will say that the boundary lines of each subdivision lot extend to the water's edge. And so it's sort of self-operating for zoning purposes. Some of the townships will accept that, and they'll say, "Okay, fine, we're good. You don't need a variance. We can build your house."
That makes sense to the water's edge.
Yep.
Okay.
Some of the plats do not say that, and so if we're in that situation, then what we often have to do is quiet title to that. In my scenario, 50-foot gap between your lot and the waterfront. And what we do is we have to find the original, the last known owner of that gap or that property, which will probably be the proprietor of the plat, and we have to file a quiet title action against that person who has long since been deceased. And then we can get title to that piece in our client's name based on the fact that it's always been used as part of that lot, and that lot is riparian now. And so the thought is once riparian, always riparian. So they have a claim to that piece above any and all else, but they don't actually have title.
Question. So on these plotted subs that don't have that clause to the water's edge, do you ever do like a blanket case and try to get the whole sub? Hey, it all goes to the water's edge, or is this all individual plots that you got to deal with on each one?
So that's actually that's a very timely question. We're considering doing some of those along the chain of lakes right now on a plat by plat basis. But typically those plats they involve a lot of people. I've done, so usually one person wanting to do something triggers it, then everyone sees what's going on, and then typically we would handle it for just that one person because they're the one in need. But they'll share that information with their neighbors, and then sometime they'll come back to me down the line, oh, now it's my turn. I've done it once where we had I think maybe a 6 to 8 house street all did it together. And then they were able to share in the survey costs and the legal fees at that point in time. But mostly it's a property by property basis.
Okay.
We saw that exact situation with I have an original cottage on Portage Lake in Pinckney, and my neighbor tore down the original cottage next door, and that's exactly what he ran into because he didn't do a survey when he bought the place. So I know that you helped him, figure that situation out. But what was interesting to me is that in the street that I'm on, there's very few original cottages left. Everything has been torn down and rebuilt. And you look at like the other neighbor on the other side of me who built maybe 20 years ago and go, I know now where his property line is, and he never went through that process of claiming the land to the waterfront, yet his house is almost on the edge of that line. His deck extends into the property that he technically doesn't own. And I go, well, how did he get his building permits approved 20 years ago when now, in the 2020s, now the townships are on this and they weren't 10 or 20 years ago?
I think that's the answer. You know, all of these various industries are becoming much more sophisticated now. The zoning departments, the surveyors, people, once you cue into that issue, they're on it. You're right. And I just don't, I think it was a lack of awareness before maybe, again, and I think our county is growing too in sophistication and size. Livingston County was a different place 20 years ago.
Now, do you find, again, and I'm fairly familiar with several of the big lakes in the area, but what I have found is that some of these bigger lakes were all subdivided at different times. So one side of the lake is going to have a different issue than the other side of the lake. And in addition to that uniqueness of all these lakes, there were also the thought process 100 years ago when it came to some of these lakes is that in some areas that no one should own the water's edge. And that the water's edge is basically community property. So I had looked at a house several years ago on Baseline in Hamburg, and there was actually, in many of these communities, there is an easement for the neighbors that are not on the water to access the lake. You know, there's a little green belt, maybe there's a picnic table, maybe there's a community dock where a few people can put boats. And but sometimes those easements are actually deeded access. And sometimes they run then along the shoreline.
Around the whole lake?
No, not, but it's just a section. It's not the whole lake. It's that neighborhood was platted in this manner. And if a buyer doesn't get a survey, they have no idea what they're buying.
Question. So you got your cottage on your lake, and if you had one of these things where there was a little common area, you know, a 4-foot strip along your water's edge, I could come over there and basically loiter, stand in front of your lake, and that's public access?
Technically, in some areas.
So-
well, not loitering. Technically, the access is for the people in the neighborhood that don't live on the water. Years ago, we did surveys on every transaction we closed. And that stopped probably now 20 years ago.
Oh, you mean mortgage surveys on lakefront?
On anything. Okay, mortgage surveys used to be done on all properties. Do you remember that?
Yeah, but now it's only lakefront new construction, isn't it?
Occasionally lakefront. That depends on the title company and how they're insuring the transaction. But, you know, there are times when it is advisable, I think, for a buyer to get a survey. You know, if
a mortgage or a stake survey, different costs. What would you advise if I was buying a lake house, Danielle?
Mortgage survey is a start, so that you know what you're buying and you know where your property line ends. Because, you know, when somebody reads a legal description, again, your lot 9 in Patrician Gardens in Putnam Township, you know, you assume you're buying a lakefront property and you assume you head to the water's edge.
Well, I would assume that's what gets Abby's phone ringing because of these encroachments and stuff like that.
Well, I had a client also on Portage. She lives on the other end of Portage, bought a cottage several years ago. And I've done the mortgage several times, refinanced them the whole 9 yards. And one time he calls me and he goes, Danielle, I got a problem. I don't know what to do about it. And I said, what's the matter? He goes, the township showed up, or the county had showed up in the neighborhood, was in a neighbor's yard. And the client had put on a new deck. And this guy looks at his property and goes, your deck's not on your property. Do you know that? And it was not a deck that was attached to the house. It was just a platform sitting on the ground, you know, to create, you know, a nice flat space, right, for the property. And he goes, what do you mean? He's got a dock, he's got a seawall, and he's got this platform in his yard. And the guy from the county goes, no, you don't own that. He goes, there's a strip of land here that somebody else owns. So I referred him to Abby, and it ended up in that situation, someone across the main road owned this green belt area that had its own tax ID number. I don't believe there were any taxes being paid on it, which was weird. And there was this disinterested, or this third party that technically owned this strip of land. So this was an older part of the lake that was subdivided about 100 years ago. And I think they ended up getting it taken care of. But then I think in that case, there were, I think, several neighbors that got involved and ended up purchasing the waterfront rights to, you know, to their properties. And that you know, somebody else having ownership to that would have no benefit. Nobody's going to go sit in somebody else's backyard, or, you know.
Yeah, that situation has come up a number of times from a number of different people, and you know, these kinds of situations get created from 100 or more years ago when someone would buy, you know, the northwest quarter of the quarter section of Hamburg Township, and so they buy the whole thing. And then they start platting things out, and they subdivide, and then, you know, they still have property that they haven't deeded out. And sometimes those pieces were assigned a tax ID number, they were foreclosed upon, and it's somewhat rare that this comes up, but this particular situation on that lake, as I understand, the easiest way forward is to get a deed from that third party, but that's not the only way forward. If there is a situation where the third party wasn't as easy to work with, as this particular person is, there would be claims to that piece, whether someone else owns it or not. If that homeowner, if your neighbor had used that property for 15 years or more, or someone before him had used it for 15 years or more, you've got adverse possession, acquiescence claims to that property, no matter who owns it. Moreover, again, once riparian, always riparian.
Mm-hmm.
If that property was originally created and it touched the water, that riparian interest is not severable. So you could go forward on that basis and say, no, third party, you can't own my waterfront. That's my waterfront. It goes with my land, even though technically it's not part of my plotted
Well,
lot
they're certainly all
one.
being taxed as waterfront properties.
Exactly. And so there's a multitude of issues. And so in that particular situation, it's easiest just to go get a deed from that person.
Right.
But if that person weren't amicable, you could go to court and get it that way.
Well, you've talked about Livingston County has become more sophisticated. Has real estate in the last, now, is it much more complex than it was 20 years ago? Or what are you seeing? Or is it just as easy, or it's the same things that are happening?
Well, I think when you have more people, using the land, and using the land for different purposes, especially in our county, we were a very, very agrarian county for many, many, many years. And we were a cottage, we were a recreational vacation area for many, many years for the greater Detroit folks. And so land is being used in a different way. And now we're much more, bedroom community. We've got a lot more folks who live here year round and new builds, and we're converting farmland into single family residence.
Stop there for a second, because that was a topic of our last show, was developments. Are you involved in these developers trying to develop land with the municipalities and all that, and affordable housing and available housing and all?
Yes, so we do condominium documents. We create master deeds and help developers establish communities, bylaws, that kind of stuff. We have some folks who are doing some affordable housing in the area. So yeah, my firm does work with a lot of those builders and developers.
Yeah, because a lot of times, I know there was a proposed subdivision by ours, and the township kind of knocked it down. It was voted out. There's some scuffling going back and forth. Do you get involved in that type of litigation as well?
Yes, we do. We would potentially assist on the development side, and then I also do work for some municipalities in the area as well.
Okay. Well, we are getting almost out of time here, so
we could go on forever.
Thank you
so much. It's fascinating, and I think buyer beware is important to understand, and people need to do their due diligence. And if you are buying a property and spending hundreds of thousands of dollars, hiring an attorney to represent you is very important. Getting a survey is important, so that you can't just look at it and go, let's cut costs. No, a survey would be pretty important, especially if you're on waterfront or lakefront.
Hiring an attorney is a part of that investment.
Yeah.
That long-term, let's call it the 401k, that retirement home.
Yeah.
It's just part of the cost there.
Well, I had a transaction literally fall apart this week, and it was Realtor represented, but it fell apart because of a legal description error. The seller started to modify the legal description to the property for some reason, never finished it. And the buyer the seller wasn't willing to go. The township had one thing on record. The title company had another thing on record. They couldn't get things to match. The seller wasn't going to make it right because they started some kind of a split or something. And you go, wow, if you wouldn't have had, a title policy to look at this, you could have bought a piece of property and you didn't know exactly what you were buying. So, meets and bounds legal descriptions, which are very common out here with all the acreage we have, that's a whole nother topic. I mean, we didn't even touch on that, but that's a whole nother thing where people can mess up a legal description and you don't know what you're buying if you don't know what you're buying.
Well, one thing that just popped in my head, we were talking about for sale by owners. Of course, do you represent both the buyers and the sellers in those transactions to be a kind of a middleman, an arbitrary person to make sure everybody's happy? Or how does that work generally?
I can only represent one party in a transaction. Okay. So my fiduciary duties would go towards one of the parties. So if I represent seller, that's my client. but I can, help the transaction along. And if, the good thing about transactional work is they have a common goal.
Okay.
Everyone wants to get to the closing table, buyer and seller alike. And so what is your agreement? I can commemorate it the way you have agreed to it, but I can only represent one side of the transaction.
Okay. Well, Abby, how would our consumer or our real estate professionals get a hold of you? Do you have a website and a phone number that you could please pass out?
Sure. My office number is 810-227-3103. We've got a nice, wonderful receptionist that does all of our intake. If you need anything, give us a call. And our website is www.crlaw.biz. It's B-I-Z.
B-I-Z. Well, that's Abby Cooper. We've got Danielle Boote. Any closing words, Danielle?
Thank you, Abby. We appreciate your time this morning, bright and early, and look forward to seeing you again.
Yeah, I would love to have you on another show. We could peel this onion forever.
Yeah.
So
all right, let's do it. Thank you guys both very much.
Well, that's Danielle Boote. My name is Victor Bals, and we will see you next time here on A Smarter Way Home.